with your
Good morning, Your Honor. Attorney Kate Faith and Ms. Lauren Murray. I apologize for my tardiness. I was held up with Judge Colvin and Quincy.
Judge who, please?
Judge Colvin.
Okay.
I hope the court got my message.
Yes, we did. And
Great.
it's a courtesy to you. All parties answered ready at 9:15, but we waited.
Thank you very much, Your Honor. I appreciate it.
All right. Okay. And Attorney Bolden, do you represent Ms. Peters?
on the violation of probation, not on the restraining order.
Okay. So Ms. Young, you represent the probation department? Okay. So first we'll address the extension of the restraining order. All parties were previously sworn, but for the record, would you tell me your name again, please?
Lauren Murray.
And you're represented by Attorney?
Attorney Kate Faith, Your Honor.
Okay. And Ms. Peters, you are here as well.
Yes, Your Honor.
So why don't I first hear from the plaintiff? Before I do that, I will read the original affidavit. Did you file a supplemental affidavit?
No, Your
For
Honor.
purposes of today? All right. So for the record, I have before me docket number 2206 RO468. The plaintiff is Lauren Murray. The defendant is Catherine Peter. This order initially was issued after hearing an ex parte hearing before Judge Bolden on August the 23rd of 2022. It was then extended for 1 year. Both parties were present at that extension hearing before Judge Griffin. Last year, it was extended for another year after a hearing. The defendant did not participate last year. That was before Judge Key. So I have never heard any part of this.
You are
At
muted.
this point, I will read the affidavit.
You are unmuted.
This is your affidavit? All right. It's dated August the 23rd, so just give me a moment to read the affidavit, and then I'll hear from you. And then if you'd like to testify, I'll hear from you as well, ma'am. Okay, so for the record, I did have an opportunity to read 2 full pages and then a 3rd page. Okay. How would you like to proceed, Attorney Fay? Does your client want to testify and give additional information?
Yes.
Involving why, or addressing why the harassment order should be extended?
Yes.
Or would you like to make representation?
Your Honor, I'll just give you a bit of a brief background and then inquire on my client.
Sure.
So, Your Honor, this is my client is collateral damage. So what I mean by that is Ms. Peter runs a blog called Masshole Troll Mafia. She has an ongoing feud for years with another blogger, Aiden Kearney, also known by the name of Turtle Boy. Those two have had a falling out. My client had a personal relationship with Mr. Kearney. So Ms. Peter, what she did was essentially weaponized against my client, Ms. Murray, in an effort to get back at Mr. Kearney. And she did so by posting several photos, as you've read in the affidavit, on her blog. Additionally, saying things directly to my client and Mr. Kearney on her blog that were threatening. At the time, Massachusetts didn't have a revenge porn statute, so per the Massachusetts SJC has said that the appropriate mechanism would be a harassment prevention order, and we needed some way to stop Ms. Peter from going ahead and posting all of this. At the original order, she did go ahead, admit that she posted all of this stuff. She sat in this courtroom, she cried tears, apologized, then she went on her blog at night and made a mockery out of the system, out of the judge, out of myself, out of the whole thing, and thought that the whole entire scenario was funny. So she has no respect for the court. So it would be my position as well as my clients that if we don't have this order in place, I'd fear what will happen to my client.
Okay. Is your client a blogger as well?
No, Your Honor, she is
Okay.
not.
All right.
She has nothing to do with Mr. Kearney or Ms. Peter. As I said, she's just collateral damage based on her relationship with Mr. Kearney that she had years ago.
Okay. So let me ask you this, please. Since this harassment order was last issued, that being September of 2023, have there been any violations?
There have, Your Honor.
Why don't we address that?
Okay, so,
And it would
On-
probably be best if your client testified. to that.
okay, so,
Everything that you've told me essentially is background, and I accept that. So I don't see the necessity of having your client, and it's consistent with what's in the affidavit. So I don't see the necessity of your client having to repeat what you just told me, where she previously has testified to that through the affidavit.
great.
But if there are new allegations that would support the extension of the harassment order, then your client needs to testify to that under oath.
So can you state your name for the record?
Lauren Murray.
And can you tell the court why you're here today?
I'm here to extend the harassment prevention order. As you know, she keeps violating it.
So since the last order and when we were here last,
Back up a little. What do you do for a living?
I work in medicine.
In medicine?
Yes.
The medical field?
Yes.
Okay. And how old are you?
I'll be 36 in a couple weeks.
All right. And in terms of jurisdiction, do you live within Boston? Do you live in Boston?
I actually just moved recently,
Okay.
but I do plan on moving back in the city within the next year or so.
Okay. All right. Go ahead then.
could you tell the court, since we were last here last year in 2023, have there been any violations of the harassment prevention order?
Yes.
Were you summoned here today to court?
Yes.
Could you tell the court who you were summoned by?
By Officer Crystal Young.
And what were you summoned for?
Probation violation.
On who?
Catherine Peter.
And what's the substance of the violation?
Should I go over the whole list? Just the reason?
Yes.
Okay.
Actually, I don't need to hear that because that's separate.
Okay.
The only thing that's before me now has to do with the extension of the harassment order. So why don't you tell me how you believe that Ms. Peters has violated the extension order? And then we can address terms of probation after that, okay? So just tell me what happened that causes you concern.
Okay, so on October 11th, 2023, I went to a court hearing to support my friend.
You went where, please?
It was my friend's arraignment in Stoughton, so I go there to support him.
Okay,
Catherine was actually in the courthouse, and she didn't leave when I showed up. That's actually a pending issue right now, pending court case.
did she have any interaction with you? Did she say anything to you?
Just looked at me,
Okay,
but it's pending right now as we speak.
all right.
It's a pending charge.
Was there a recent time where there was interaction between you and Ms. Peter?
Yes,
Could you tell the court the date of that?
this was July 22nd. I was outside of Dedham Court with a bunch of friends. She drove by in her car, rolled down the window, stuck out her middle finger, and yelled, "Go kill yourself," in my direction. I was standing feet away.
How close were you?
She was right here. I was probably right where he's standing.
So in terms of a distance, what would you suggest that would be? Just for the record,
Say about 20 feet or so.
20 feet?
Not 20 feet, maybe like this.
That's about 10.
10. Sorry,
10
my
feet.
brain's all.
That's okay. 10 feet?
Yes,
Okay. And how do you know it was directed to you?
because she was looking right in my direction, as she said, "Go kill yourself."
Was there anything in between you and Miss Peters?
No.
No obstruction?
There was a lot of people. I was standing right here, and she looked right in my direction. And previously, I had testified saying that I was suicidal, and I took that as a direct thing towards me.
When had you previously testified to your mental health?
So there was a trial last year, I believe it was October 26th, where she took a cloth, and I had a victim impact statement where I explained everything. And
Okay, so it was an admission to sufficient facts
Yes.
previously?
yes,
And is it your understanding that that's when she was placed on probation?
yes,
Okay. All right. Did you report the incident?
I did, yes.
And to whom did you report it?
It
The Dedham
was-
Police?
Yes, I actually have it right here too.
All right. Any other questions?
No other questions, Your Honor.
Okay.
Can you tell the court if you're in fear of Ms. Peter?
Yes.
And what are you in fear of?
Her continuing to show up where I am, attack me online, just in general, even being here in the same courtroom, I feel uneasy.
Okay. So a lot is going on in Dedham, as we all know.
Yes.
So on July 22nd, when you say you were outside of the Dedham courthouse, for what case were you there for?
This was actually, I believe it was Aiden Kearney's hearing that day.
Okay. All right. So since July 22nd, has there been any contact by Ms. Peter towards you?
So on August 9th, she showed up to Dedham again, and the officer had to tell her to leave.
When you say an officer, a police officer? or
Yes, a
court
police officer, state trooper.
And how was this state trooper made aware of the existence of the harassment order?
I had told him right away. I even had the papers on me just because she showed up before. So just in case, I keep them with me.
Okay,
So I did have the present.
all right. And she did comply with the request by the state trooper as far as you know?
She did, yes.
Okay. Anything else you want me to consider?
Also, there was another date she didn't violate, but she was in a pizza shop that I normally go to when I'm in Dedham, and I couldn't even go there that day because she was sitting in there. So it's just having her in the area at all makes me uncomfortable.
Okay. All right. Attorney Fay, anything else?
No, Your Honor.
All right. So I know there's two sides to every story. If you'd like to testify, you're welcome to do that. You're not required to. Do you want to? Okay, so first tell me your name.
My name is Catherine Peter.
I can't hear you.
Catherine Peter. I'm sorry, do I need to speak into this?
Okay, so could you scoot that, there we go. And if you folks just want to move a little, just because I want to be able to see. Okay,
Thank you. My name is Catherine Peter,
and how old are you?
36 years old,
36?
Yeah.
And what do you do for a living?
property management.
Property management?
Yes.
Now, there's been a representation that you have a blog. Do you still have a blog?
I do. And I've been covering quite extensively both the criminal case of Aiden Kearney, her ex-boyfriend, as well as I've been covering the Karen Reed case and a lot of the supporters and the behavior that's been leveled at the O'Keefe family, as well as the victim witnesses in that case. Furthermore, I think that for context here, so that we understand, Miss Murray was engaged in a relationship with the married Aiden Kearney at the time of the blog. And I do absolutely, at this point in time, still feel that posting those pictures was wrong. I'm not going to try to gloss over that. I haven't done anything like that since. It was wrong. I took the quaff because I acknowledged that it was wrong. I don't want anything to do with this woman at all. Even when we go back to the original affidavit, I've never called her. I've never texted her. I've never been to her home. I've never tried to initiate contact. I would definitely take issue with Miss Murray's characterization that I'm showing up where she is, when I think it kind of comes through in her testimony. She's showing up where I am. So we have a pending matter in Stoughton District Court. Miss Murray gave a partial story versus what she told the police, I think because she has realized that her version to the police is going to fall apart in discovery, and it is kind of strains credulity. So I was at the courthouse. I was there for a lawful purpose because I am a potential witness against Aiden Carney in his criminal
What
matters.
incident are you referring to?
Stoughton District Court, the first violation from October 11th. That she is. So I am a potential witness against Aiden Carney in his witness intimidation case. Miss Murray is aware of this. Mr. Carney is aware of this. They are working in tandem at this point. They've said so on social media several times. Miss Murray does not have a blog, but she is active on social media and she posts about me often. I was at the courthouse. She showed up per her account about an hour after I was there. I never saw her. I was never alerted to her presence. I stayed in the courtroom. I went downstairs to meet with the special prosecutor and the rest of the group that I was with, and then I left. 9 hours later, Miss Murray went to the Stoughton police. She said that I was there, that I was removed by a state trooper, that I left the premises, that I then somehow snuck into a courtroom, Your Honor, with metal detectors, teaming with state troopers and court officers, that I somehow snuck back in and that I sat down and that I was in her proximity. I don't even know that I was in her proximity. I question that, as particularly where she reported this 9 hours later. But lo and behold, the police didn't move forward at first. She continues to badger them. About a week later, Mr. Carney pops up and suddenly he's a witness in this and he can say that I looked in her
So
direction.
how do you know all this information?
Because it's on the police report, Your Honor.
Okay.
Yeah.
Were you charged with the violation?
I was, and I wish that I had right now, for Your Honor, we are looking for the surveillance video from the courthouse to show that I never left, as well as the body worn footage. It is pending right now, yes.
Who represents you in Dedham?
Attorney McLeod,
Attorney who?
Richard McLeod.
Richard McLeod?
Yes, Your Honor.
Okay. All right. So let's talk about the incident involving in August.
I'm sorry, August 9th, we're now moving to?
The incident, oh no, July 22nd.
July
So
22nd.
There's been an allegation, a serious allegation, that you spoke directly with the plaintiff. Did you do that?
I did not. I did not. I was in my car. I actually have someone here today that can absolutely confirm that. That case was a case involving my friend, Lindsay. She was a victim in the case. Because of all this ongoing nonsense, mostly with Aiden Carney, as he was the defendant, I opted not to go to the hearing, but I did have lunch with her in Dedham beforehand. So I live in North Attleboro. I put my address in my GPS to go home, and unfortunately, it took me by the courthouse. Now, and just for further context, this court hearing was scheduled for 2 o'clock. I'm driving by the courthouse about 1:30. So we felt that we had given it enough space. Again, I wasn't anticipating Miss Murray. I don't have a GPS tracker on this woman. I don't know what street corner she's going to appear on, but I did anticipate there could be an issue with Mr. Carney. So I felt that we had given enough time, 1:30, the hearing was at 2, for my friend to go meet with her lawyer and me to go home. As I approach the courthouse and I'm driving by, I get stuck at a red light. She's in a group of about 50 people. They immediately recognize my car. They start screaming at me. And this is all on video that was actually provided to probation. You'll see in the video that, yes, I did have my finger out the window. I never looked at her. I may have looked out of the corner of my eye at the crowd a couple times, and I think that's even reflected in the police report, but I didn't look at her. I didn't see her. There was a group of 50 people screaming at me. Probably shouldn't have flipped the bird. That was not appropriate, but it's not a violation, nor was it directed at Miss Murray. And furthermore, in this video that she has provided probation, I don't yell anything. And if you look at the police report from that instant, Miss Murray gives actually 2 versions of events. First, she says that I yelled, "Go fuck yourself." And then later on, she changes the story and she says, "I go kill yourself," and then connects it to this victim witness impact statement. I didn't appear at the last one because I don't want anything to do with this woman. So in theory, her having an order on me doesn't have an impact on my life, but this is a clear abuse of the process to weaponize me. I suspect that it's to punish me for my ongoing involvement in the criminal case against her ex-boyfriend, regardless of the reasons. I mean, this order has become inequitable at this point. So I don't want anything to do with her.
How do you figure that it's become inequitable?
She's using it to manufacture allegations, and probable cause is very low. So it's very easy to get into court to get that in the door. It's her word against mine. And then I have to go through the entire court process to disprove these allegations that she's manufacturing. As far as August 9th goes, that's not exactly what happened. I showed up to protest on behalf of the O'Keefe family. She happened to be in the crowd. As soon as I was made aware of this, I told the state troopers, I will leave. They said, no, you can stand down the street. You know, I think I was about 100 yards away. So I stood down the street, quietly holding my sign. Miss Murray and Mr. Carney, and this is in a police report as well, tried to approach me on, I think, 3 or 4 different occasions. They tried to go down to the police to get me arrested, but luckily I had a sergeant with the Dedham Police that was in my presence at all times. He notes in his report that it looks like they're the ones who are harassing, intimidating me, not the other way around.
Okay, so at this, do you have any questions for Ms. Peters? Go right ahead.
Ms. Peters, so you run a national troll mafia YouTube, correct?
It's not very active right now, but it still exists, yes.
And in 2022, you did post photos on that website of my client,
I did.
and you also posted my client's address.
I did not.
Correct?
I did not.
And did you also state, Aiden, you told somebody I wouldn't have the balls to show up at your fucking girlfriend's house and that I'd never be able to find your address. You're wrong on both fucking accounts, son. And you should really be worried about the kind of videos and photographs I have right now and where they're gonna go.
I would have to see the direct quote. It sounds somewhat consistent with what I had written. I don't know about and where they're going to go. I feel like you added that.
And additionally, didn't you also on that show state that Lauren Murray was collateral damage because she has a relationship with Mr. Kearney?
I do feel that he was treating her as collateral damage, yes.
Meaning, when I say collateral damage, ma'am, what I mean is that you harming her is collateral damage, correct?
No.
And you have a relationship, a friendship with a woman by the name of Lindsay Gattani, correct?
Correct.
And Lindsay Gattani is here today,
She is.
and Ms. Gattani also has an order on Mr. Kearney, correct?
She has a domestic violence restraining order because he
Yes,
battered
ma'am.
her. Yes.
And you knew that Mr. Kearney would be here today, correct?
I knew that, I mean, I would
Yes or
assume,
no?
I did, yes.
And so you made a phone call and had Ms. Gattani show up here today, correct?
No.
No further questions.
Okay,
Your Honor, I do have the video of Ms. Peter driving by the courthouse, sticking her finger out and saying, "Go for yourself."
do you want to introduce that at this point? And then you have a witness?
I do.
Okay, so why don't I see the video, and then if you'd like to call the witness, I'll hear from your witness. Time. Janelle? Okay, thank you. Okay. So may I ask who took the video?
It was, I can't remember exactly who sent it to me, but it was somebody who's right there with me.
All right, so let me ask you the obvious question. That, at minimum, can only be described as a circus-like atmosphere. So the statement that you are alleging that Ms. Peters made, why do you believe it was directed towards you and not someone else within that large group?
It was just the wording of it. And I'm regards to the statement that I was suicidal, he was going to wrong example repeat this. So it's just those words and like anger. And I have to be standing right here. I was actually wearing a black dress.
Okay, all right. Why don't I hear from your witness?
Sure.
All right, tell me your name, please,
Lindsay Gattani.
and where do you live?
I live in Medfield.
Medfield?
Medfield, correct.
And what do you do for a living?
I'm currently unemployed.
And how old are you?
38.
Okay. And how do you know the defendant in this matter?
We became friends because she actually has been started out kind of advocating for me because of my ongoing case with Aiden Carney. I have a restraining order against him, and she was familiar with him because she used to work for him, and I had reached out to her for help at one point, and we just became friends after that.
Okay, so how do you know Aiden Kearney then?
I dated him very briefly.
All right. And how long ago were you in a relationship with Mr. Kearney?
It was about September 2023 to December 2023. Again, very briefly.
So you knew Aiden Kearney, it would be fair to say, before the plaintiff knew him? Or after?
After, correct.
Okay. So do you know the plaintiff at all?
No, I've never met her.
All right. So did you want to ask your witness some questions?
Sure. So let's go to that incident in July 22nd, 2022. Why was I in Dedham?
I was not there July 22nd, but
No,
I,
I'm sorry, what are we doing? I thought that was, is it July 11th? I'm sorry, Your Honor, the date of this Dedham courthouse incident. Was it 11th? Sorry, July 11th.
July 11th.
July the 11th?
July the 11th.
Okay.
So I had met, should I direct you or into, Okay. So I had met Miss Peter at a restaurant in Dedham along with 3 other friends. We went to get lunch early in the day before I had a court hearing with Eden Carney in the afternoon at 2:00 at the Dedham Superior Courthouse. So I met
Were
with,
you a witness in the case?
I'm a victim.
You were the victim
Yes.
in the case? Okay.
So I met with Miss Peter and 3 other additional friends at a restaurant in Dedham, somewhat close to the courthouse. And we had lunch. We were there for at least a couple hours, maybe possibly longer. And so Miss Peter knows that she cannot go to any of the court hearings with me as my friend, unfortunately, because of the harassment prevention order that Mr. Carney has against her. So she met with me for lunch, and as we were leaving, or before we left, she told me she had to leave and go home, obviously, because she couldn't go with me, and told me she was going directly back to her house, but to call me afterwards and let her know how it went. So as far as I know, at that point, when she left the restaurant, she was just going straight home.
But you weren't with her when she left the restaurant?
Just at the restaurant, I was with her. I didn't,
Right.
I didn't go in her car with her, but she made it a point to tell me,
That
obviously,
was her intent.
that she was, if she could not go to the courthouse, she knew she couldn't be there because Mr. Carney would be there. So she went out of her way to, even though she's a good friend of mine and wanted to be there with me, she knew she could not be there and went home when my other 3 friends went with me. So I believe she did everything in her power, and, she put in the effort to avoid having any contact with him at all.
Well, you weren't there though, right? When the alleged contact?
Not when the contact occurred, no,
All
but
right.
yeah,
Thank you. I'm sorry you're the victim. Is that case still going on?
it is.
Okay. All right. Do you have any questions for this witness?
I do.
Okay.
I'm sorry, I wasn't.
Briefly.
Very brief, Your Honor. On or about December 23rd or 24th of 2023, there was an alleged incident that was reported to the Massachusetts State Police of domestic violence between yourself and Mr. Kearney, correct?
Correct.
And that was reported directly to Lieutenant Ryan Kelly?
Correct.
Correct. So you didn't call 911 when that incident happened, correct?
I'm sorry, what does this have to do with Ms. Murray?
Agreed. No. Move on.
That case was dismissed.
Move on. Move on.
Your Honor, it goes to her credibility.
Yeah, I'll note your objection.
Thank you. No
She's
further
not a
questions.
percipient witness, so essentially she testified to what she believes was the intention of Ms. Peters. So it's of minimal persuasive value. Let me just say that. You need not ask for any more questions.
No, I have no further questions.
All right. Do you have any other questions?
I do, I'm sorry. So you say you've never met Miss Murray, but have you ever had communication with her?
Yes, I
Haven't
have.
you what?
Had communications with her?
Okay, we're getting into territory that has nothing to do with the alleged violations that occurred. So I'll note your objection. You're all set, ma'am.
Okay, thank you, Your Honor.
Good luck to you. Okay. Anything else?
I would just state also, Miss Murray's been quite active on social media. It was August the 25th. She did put up a social media post on X, formerly Twitter, referring to me, where she said, "I'm playing their game right back at them. They're just upset because I'm going to put their leader in jail." She's also made several disparaging comments about my children. She's engaged in, there was a photograph of myself and Miss Gattani actually on the Cape at the beach with her children. We had clandestine pictures taken of us in the group that Miss Murray and Mr. Carney belonged to. They were posted online. Miss Murray took it upon herself to make disparaging comments about myself and my children. She's made several comments that she's going to put me in jail and that she's playing a game publicly on social media. I don't feel that this is a game.
Do you have evidence of that?
I can pull it up on my cell phone, Your Honor.
If you want me to consider that, then you need to
Can I
actually show me evidence.
Can I just grab my cell phone?
Yeah.
Would that be all right? Thank you. Okay, so I need to show.
Yes.
Okay, first, absolutely.
Basis of the objection.
There's no data, I don't have any, there's no data at all on any of that. And furthermore, there's no names mentioned.
All right. Can you authenticate?
Authenticated as far as, would you like me to pull it up on the profile or would you like me to?
No, that's up for you. There's been an objection that has been raised.
Sure.
So if you want me to consider that, you have to establish when it was posted and who posted it.
I'll just drop that because I have her blocked on social media. It was sent to me, so I don't know if I could have somebody else screenshot it that's not blocked right now and send it to me, but otherwise.
Okay, so I can't
We'll just
consider
drop
that then. All right. Okay, anything else?
No, Your Honor.
All right. Anything else from the plaintiff?
Your Honor, in closing, I just want to say, when I started, I told you that she's collateral damage. With Ms. Peter and Ms. Catani's testimony, the number one thing that we're hearing is Aiden Carney, Aiden Carney, Aiden Carney, Aiden Carney. So I don't care about Aiden Carney. And she's being harassed and tormented because of a prior relationship with Mr. Carney, and which is now just strictly a friendship with Mr. Carney. She testified in this court that she was suicidal. Ms. Peter pulls up, says, go kill yourself. So I understand that she would take that and believe that that was directed at her. I believe that that was directed at her as well. The only thing that protects Ms. Murray from further damage on social media and in person is this order. So I am going to ask Your Honor to please extend this order.
Okay. I'll hear from you.
I'm sorry.
I'll hear from you.
Oh,
I know there's two sides to every
There
story,
is.
so this is their side.
I mean, they're alleging damage that simply isn't occurring here. I mean, that incident, again, a circus-like environment is apt, right? I was being screamed at. I would question why Miss Murray, if she's truly in fear, is even in a crowd that I could have driven by without incident, right? They could have just let me drive by. There was no need to, I mean, people screaming, literally almost jumping into the roadway. If Miss Murray is in fear of me, why is she engaged in that sort of behavior? If Miss Murray is engaged with me, why is she showing up to places where I'm located? She stands before Your Honor, and I think really her intentions are crystal clear when she says she doesn't even want me in the town of Dedham. I would also question if this court even has the jurisdiction to extend this order, as Miss Murray has indicated that she no longer lives in the area. I am under the assumption that Miss Murray relocated to Lakeville, Massachusetts, when she had a dispute with her landlord over Aiden Carney being allowed in their home. He wasn't allowed. She left the home. I believe that she's in Lakeville now. I believe that would be the proper venue if we really want to do this all over again. Again, I don't want anything to do with this woman. The only reason that I'm even here today fighting this order is because this is becoming inequitable at this point. She's using it as a sword and not as a shield as it should be.
Okay, thank you.
Absolutely.
All right, so this is my decision. For the record, I do credit the testimony of Ms. Lauren Murray. I am going to extend the order. I do find that she has met her evidentiary burden and has established by a preponderance of the evidence the necessity for an extension of this harassment order. In making this decision, I am persuaded by the underlying factors and reasons for which the order was initially issued. The allegations to which the defendant admitted are extremely concerning, disparaging to her character, are vile on many levels and did clearly establish a malicious intent to harm the plaintiff and to harm her reputation, her relationship with other individuals, and to place her in imminent fear, continuing fear. So in extending the order, the underlying allegations are a major factor. I further find that there was a violation of the order. It has been established by a preponderance of the evidence. Without question, as I mentioned earlier, the incident, and I believe it's July the 11th, was a circus atmosphere, no question. You were there for legitimate purposes. But I do find that there are many ways to leave that area other than driving directly in front of Dedham Courthouse. So any pizza place that you were enjoying lunch with, you easily could have gotten onto Route 1. You could have taken Washington Street to avoid an area where in all likelihood there would be a confrontation with the plaintiff, well knowing that the plaintiff has an ongoing interest and relationship with Mr. Kearney. So for all of those reasons, I am going to extend the order for 1 year, and I'll note your objection for the record.
Thank you.
And I need to remind you, please, this is a civil order, but it has criminal penalties. So if you do violate it, you could be arrested. All right, thank you.
Thank you kindly, Your Honor. I stand corrected.
Okay, so now in terms of the, all right, Attorney Golden,
Yes, Your Honor. This is a stipulation.
okay. So I just need to ask you some questions, Ms. Peters, Ms. Peter, excuse me, I know it's singular. Today you're represented by Attorney Bolden. You are before the court for what is known as a violation hearing. Your attorney has informed the court that you wish to stipulate. That means that you agree that you're in violation of the terms and conditions of probation. Before I accept that, I need to ask you some questions, please. Do you understand that you do have the right to a hearing in this case, that you do have the right to testify further,
Yes, I
that you
understand.
have the right to call witnesses, that you would have the right to challenge any evidence introduced against you? Do you understand that?
Yes, I understand.
And you understand that in stipulating to a violation of probation, you're giving up that right to contest anything that the probation department is going to represent?
Yes, I understand.
And do you also understand that although there may be an agreement between your lawyer and the probation officer, this court is not obliged to adopt that recommendation? This court can impose any sanction that it thinks is necessary under the circumstances.
Yes, I understand.
All right. And are you satisfied with the legal representation that you have received from Attorney Bolden?
Yes,
Has she answered all your questions?
yes.
Do you have any questions for your lawyer now?
No.
All right. So for the record, I find that Ms. Peter has made an intelligent, voluntary, knowing, and waiver of her right to a hearing, and I will adopt the stipulation to a violation of probation. First, I'll hear from probation, and then Attorney Bolden, I'll hear from you.
Yes, Your Honor.
Good morning, Your Honor. For the record, probation officer Krusty regarding the open probation matter, which is case 2206 CR 1091. Ms. Catherine Peter was on a continued 2-hour finding. It started on 10/26/23, and it's actually supposed to end tomorrow, 9/6/2024. And the basis of the conditions were that she was supposed to abide by restraining order terms, do not post about the victim on any social media, and pay a $50 victim witness fee by 9/6/2024. That's a probation order that was written up by Judge Key on 10/26/2023. On April 2024, I brought the matter forward for a violation. So this is the probation violation has been going since April. April 24th, 2024, when Leominster Court notified us of the new arraignment that was scheduled to be pended in their court, and that was case 2461 CR 000273. That one was witness juror intimidation, police court officer intimidation. What happened with that case was, that's the basis of the original violation. We've had a couple of court dates, and then, so that was the original basis of the violation, but then on 7/11, when Lauren Murray contacted me about the video, I amended the notice and put down amended notice filed for violation of a restraining order on 7/11/24. Then we ended up having a court date. When I received the information regarding that Leominster case, we found out that a lot of the information in that Leominster matter preceded the date that she was placed on probation. So on June 24th.
So therefore, the Leominster matter is not a proper basis for the probation
Exactly.
surrender hearing today because it preceded her being placed on probation.
Exactly.
Okay,
That's why I scratched it out on 7/29/2024 in open court. But a new restraining order issued out of Leominster Court involving Aiden Kearney, and that was 2461 RO 0081. So I amended the notice on 7/29/24 regarding that new restraining order involving Aiden Kearney. And so the only two issues at this very moment is that new restraining order and that violation of the restraining order that we just testified about at the restraining order. And those are the two bases of the violation.
the restraining order involving Aiden Kearney and this restraining order?
And that one that we just, the 7/11 incident driving by in the car, that's the 7/11 incident regarding Marvin.
Okay,
It's a
So-
video in the car.
all right. So what's your recommendation?
The probation department believes that she be found in violation and that her probation be extended for an additional 3 months. And that's based on talking to the policy supervisor.
All right. So has Ms. Peter, is this an administrative probation?
It wasn't administrative probation.
So was she required to do community service or was she required to report
She and I talk every 3 months.
every 3 months? Okay. Are you seeking a guilty finding?
Our department is asking, no, we're not, we're asking that the continuance of our findings be extended for 3 months.
So that if there's full compliance after 3 months, probation would be dismissed, the case would be dismissed. All right.
And can I say one thing?
Yes, of course.
My department wanted to make sure, to let everyone know that the victim, as we know, is present, and if she had any, she said that she wanted to be heard regarding this position. That's what, our department was saying, to let the court aware that she's here, and she asked her if she wanted to be heard regarding our disposition, and she said that she didn't want to be heard.
Ms. Murray wants to be heard further.
So she'd be underlined based on the probation matter.
All right. Is she still here or did she leave? Oh, okay. All right. Why don't I hear from you?
Your Honor, we have discussed this. I think that the 3-month extension is an appropriate recommendation. Our stipulation is primarily based upon that video, which is the July 11th issue. As far as the restraining order itself, Your Honor, that's a civil order. I question whether an issuance of a new civil order is a violation of probation, but given that there's the second alleged violation, we are stipulating. I obviously have watched that video prior to today, Your Honor, and yes, she does seem to hold up her middle finger. I question whether you can
She
see her.
seems to or
Well,
she does?
She certainly does, Your Honor, but I question whether you can actually hear or see her say anything in that video. I certainly couldn't. But obviously it has resulted in new criminal charges in Dedham. So we are stipulating for those reasons, but I do think that the 3-month extension would be sufficient given the circumstances.
Okay.
I have no time to type anything up, but I just want to.
No, I have all the time in the world. Go ahead.
I just want to say that in relation to Laura previously, and I'm just afraid it's going to continue and go on.
Okay. Anything else? All right. Thank you. Thank you. So quite frankly, I'll be real honest with you, I wish I could fashion a disposition that would make this activity stop because it's not productive. It's harmful to a lot of people. And that's what's troublesome because probation is supposed to modify behaviors so that things don't get repeated. That's called recidivism, when things get repeated. And right now, I'm trying to think of something that would be appropriate. So I'm open to suggestions other than just the 3-month extension. I'm just concerned that the behaviors are going to continue.
I mean, Your Honor, you've already extended the restraining order for a year. Mr. Kearney also has a restraining order that I think is open for another at least 9 or 10 months. Those are additional things hanging over her head that could result in additional criminal charges, which could obviously be additional violations were they to happen. I don't see any other appropriate conditions that could be added at this time. We certainly can't order someone to take down their blog or order someone to stop blogging. It's her freedom of speech. Unless she violates the order with her blogs, obviously. But I don't see any appropriate conditions that can really be added in this situation.
Okay.
That, the decision that we came up with was all the department heads. Consulted.
All right. I'd ask for some community service. There has to be something additional. Something to hopefully impress upon your client that this level of this intensity can't go on, or she's going to end up with a criminal record. I don't think you have to at this point. So you came real close to getting one because a violation has been found. If I enter a guilty, then you end up with a criminal record. So going forward, that's just going to cause you serious harm. So in consideration of everything, I will adopt the joint recommendation of I won't impose the guilty, but I am going to extend probation. I'm going to require that you do 30 hours of community service. You can do it at a nonprofit. It needs to be done though in the next 90 days. You do that and the case will be dismissed. If you don't do that, or if there are additional violations or even allegations of violations, if the judge finds them to be credible, then a guilty finding would enter. Trust me when I tell you, a guilty finding is only going to complicate your life. It's not going to make it easier. It's not going to be a badge of honor or a badge of courage. I wish you the best.
Thank you.
All right. Thank you, Attorney Bowman.
Thank you.
Thank you.
You still want to provide that restraining order?
Yes.
The original condition?
Yes. So obviously, let me just repeat the obvious. You cannot be arrested on any new matters. You must abide by any and all restraining orders that are in existence. Do you just have those two? One involving Ms. Murray and one involving Mr. Kearney?
Correct.
All right. Do your best to abide by them.
Well, as long as they allow it now.
Chapter 22 RO 460 order is extended 1 year until September 5th, 2025. Without agency R1091 after supervision violation found is a finding due to December 5th and 30 hours of community service. Thank you.
Thank you.
You can see the audience give you a copy of the order.
Did you say 9-5?
I'll call this bang bang. Seriously? I will fuck you up. I will beat your ass. I will fuck you up. Pull up, bitch. I will fuck you up. I will beat your ass. I will fuck you up.
Objection. Objection.
I will fuck you up. KO. Bang bang. I will fuck you up. You're a bitch, bro. I will fuck you up. I will beat your ass. I will fuck you up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang, pull up. Right?
Yeah.
The bang bang, the bang bang, pull up. The bang bang, the bang bang,